Example number 5. Okay. And let's talk about terminating a periodic tenancy. Terminating a periodic or terminating a periodic tenancy. It's a mouthful. Okay. You can terminate a periodic tenancy early, but you must notice that it's sufficient, right? A tenant can terminate a periodic tenancy early, but you must provide sufficient notice. Okay, here's where it gets a little tricky. There are different rules for the common law and the modern law. Give us your hand up, Shadi. Before the, yeah, you're right.
Before whatever period they're in.
Right. Right. So let's say it's a periodic tenancy that lasts a year. You can terminate before that year runs out if you give sufficient notice. Not always, though. Okay. Yes, Alex.
So
Let me do the example. It'll make sense. It'll make more sense. It's hard to. This topic's hard to visualize in the abstract. Let's do the examples. Okay. Here, there are different rules for the common law and for the modern law. I'll do common law first. I'll do modern a little bit later. All right. So let's look at example 5A. It says from landlord to tenant for year to year, starting on January 1st of 2030. Okay. All right, so Linda, let's walk through this one step at a time. There's a year-to-year lease starting on January 1st of 2030. What happens, Linda, on January 1st of 2031 with this lease 31?
it's just going to continue for another year.
It renews for another year. But what if you want to move out on January 1st of 2030? 2031, right? You want to move out on January 1st of 2031. What must the tenant do?
Give notice that to terminate tenancy, but I think it has to be before 6 months for common law.
Okay, that's right. At common law, with a year-to-year lease, this is important. Just write this part down. At common law with a year-to-year lease, the notice must be equivalent to half of the 1 year period. Again, a common law with a year-to-year lease, the notice must be equivalent to half of the 1 year period. Half of the 1 year period. I just put up here. In other words, 6 months notice. You must give 6 months notice at common law with a year-to-year lease. Okay. Half of the period is 6 months. There are 12 months in a year. Lord help me. Half of 12 is 6. Look, I'm going to assume you know nothing. It's a safe assumption, which I unfortunately have to make. I have to waste time counting how many days in the month are, but that's what we're going to do. Right? So let's see. What are the 6 months? Right? July, August, September, October, November, December. And you have to work backwards. If you know you want to end the lease on December 31st of 2030, you count December, November, October, August, July. So Linda, the question is, what date must you provide notice on to leave at the end of 2030? What date?
June 30th.
No. I mean, you can, but you can go a little bit later. You need 6 full months notice. So what day would you give your notice on?
Before
July
July 1st.
1st. Okay. Okay. If you give notice on July 1st, you have 6 full months. Okay? July 1st, you have all of July, just all of October, all of November, all of December, 6 full months. Okay? Now look at example B. What if you give notice on July 2nd? You missed your window because we're not going to be 6 full months. Okay? In example 5A, the lease will terminate on December 31st of 2030. It will not automatically renew on January 1st of 2031. But if you do it on July 2nd, right, you do not have 6 full months of notice. It only gives 5. If you do it just 1 day later, right, 1 day later, the lease will renew on January 1st. You have a full additional year of the leasehold. Okay? So the trick here is counting 6 full months. July, August, September, October, November, December. 6 full months. That's sufficient notice. But by doing on the 2nd of the month, you kick it over. There are actually some leases that have this policy. When I was much younger and didn't know what the hell I was doing, I moved to Washington, D.C. for a summer job, and I'm not kidding you, I moved on, I think it was actually June 2nd, and I wanted a 3-month lease. And they actually said, we will not start a lease on the 2nd. So basically, the 3 months would have ended in September, right? I just wanted June, July, and August for the lease. But because I got there on June 2nd, they wanted to basically make the lease start date effectively 3 full months, which have been all July, August, and all September. And I had to fight with them over this. But the concept of 3 full months matters. You want to start on the first day of the month. It actually does make a big difference. And you want to make sure you provide your notice by the first day of the month. Now, June 30th is not wrong. You can give your notice early, right? You're not required to wait there. But if you do it by July 1st, you get 6 full months. Okay? All right. Yes, Lilia.
So on 5A, that person can stay
Through the end of 2030.
to the end of December.
Correct. And then he's got to get out. But in 5B, how long will the lease run for? Well, Lillian, in 5B, did the tenant give sufficient notice? So when will the lease terminate? I'm sorry? Well, he gave notice to terminate, right? And you must give at least 6 months. Okay, well, let's try this again, right? So in 5A, what's the day of the termination? Lillian? What year? In 5A, the lease terminates December 31st of 2030. Okay. Now, Lillian, go to 5B. Did he give the required 6 months notice? He did not. What happened on January 1st of 2031? It renews. But did he give sufficient notice for it to end the following? He did. He gave a lot of notice, right? He gave almost 18 months notice. Right? Lillian, did he give at least 6 months? By missing 1 day, by going July 1st, July 2nd, right? By going July 1st to July 2nd, you kick it over a full year. But you provided notice. The landlord's on notice, and it'll terminate on the 31st of the next year. Everybody with me? Yes, Leah.
What if in the notice he gives a specific date that he wants to leave by?
Well, that's nice, but it's not effective, right? Under the common law, the rule is 6 months. So if he said, in 5B, I want to move out December 31st, he'll say, that's nice, but That's not sufficient. You've only given me notice here. Now, is your question, could it be ineffective altogether if you give the wrong date? Is that your question?
My question is, it obviously doesn't end when he wants it to on the date he said,
Right.
but does it automatically transfer to the next?
I think it would, the landlord would say, this is not effective for this year, but I'll accept it for next year. And that's the earliest you can get your lease. I think. I mean, suppose a landlord could say, if you only gave notice for a specific date and that date is not feasible, then the notice is altogether ineffective. But I think you would probably treat it as effective for the next year. All right, everyone with me? Yes, Trish.
Would like a notice of vacating be different from like not agreeing to like pay an increase in rent? I think it would.
Well, you can increase the rent during a lease, right? That's not permissible,
Okay.
right? You can't randomly jack up the rent in the middle of the lease. That's not allowed.
I guess a better way to phrase this question is like, if the landlord doesn't give the tenant like that much notice on the rent is being raised, like if it's just a couple of days or something.
There's no requirement of any notice when the lease is up.
Yeah. Like there's no.
Right, with a periodic tenancy, the lease stays, the rent stays the same.
Okay.
Right, you can't increase the rent in a periodic tenancy. Okay. The point of periodic tenancy is the lease goes on and on, the rent stays the same. Unless there's a provision in the lease saying we can increase at certain intervals. Then that's a matter of contract.
And like if the rent stays the same, then probably like all the provisions. Also.
Right, which is why periodic tenancies are very rare. Landlords want to lock themselves into a rate forever. All right, questions? All right, so that's 5A and 5B. Again, it's very important that you know the differences between how to provide 6 months notice, how to count 6 full months. Okay. Now let's try example 6A. All right, 6A says from landlord to tenant from month to month, starting on January 1st of 2030. On July 1st of 2030, the tenant provides a landlord with notice to vacate. Okay. Caden, when does this lease terminate?
July 31st,
How do you know that?
because from month to month, you have to give a month.
Correct. At common law, I'll put the rule up here. You can see it. Okay. At common law, the month-to-month lease, the tenant must provide notice equivalent to 1 full period. With a month-to-month lease, the tenant must provide notice equivalent to 1 full period. In other words, 1 month. And that's actually 1 calendar month. As we know, some months have 28 days. Some months will have 29 days. Some months have 30 days. Some months have 31. Whatever that month is, that's the month you use. And I don't want to keep harping on this, but when you have litigation schedules, you have to count days, right? Your brief might be due in 14 days. And if you don't count the days right, you default to your deadline, right? So many lawyers filed the briefs 1 day late because they forgot December had 31 days, right? If you don't count your days correctly, and maybe you have to accept weekends and holidays, right? There are very intricate rules on counting days for briefs. And I mean, I'm not being facetious. It's legal malpractice to file a brief a day late. So this is actually something that I regret. Maybe we should teach this orientation. I don't know, but how to actually count days, because it's very, very important, right? If your brief is due, within 1 month after a certain thing happens, right? There's a statute of limitation, right? You have to count 1 year from when an event happens. You have to count what 1 year is. That's not going to be just January 1st, it'll be December 31st. So this topic it will plague you if you do it wrong. And I mean, generally when pro se litigants file stuff late, courts can excuse them because they didn't know how to count days. That's an issue that often comes up with people not attorneys, but you have, no pun intended, you're on notice. So that's all I'll say about it. All right. So he's right. In example 6A, The lease terminates July 31st of 2030. The tenant is not responsible for the August rent. All right. Now, Suresh, take a look at example 6B, please. It says, from landlord to tenant from month to month, starting on January 1st, 2030. He gives notice July 2nd, 2030. When will the lease terminate?
August 31st,
Correct. Why August 31st?
because he didn't give sufficient notice to vacate at the end of July. But it would be sufficient for August.
Good, very good, right. Here, he did not give sufficient notice to terminate it by July 31st. But the notice is effective to terminate the following month, which is August 31st. So basically, September 1st, he's out. He doesn't pay rent for September. Everyone get that? Lillian, that makes sense? Okay, good. I can tell you a question. I can tell you were like looking up. Yeah, go ahead.
Can you take back your notice if you like change your mind?
That's a good question. I don't think so. I think it's because think of respect to the landlord. If your tenant says, "I want to leave," July 31st, that means you have to find a new tenant, and then someone's expecting to move in that day, right? It creates problems when someone holds over. So I mean, it's not that you can't take back the notice. You can stay, and there are problems to hold over tenant as well, but it creates with whoever's supposed to move in later. Good question. Yes.
For the periodic tenancy, does the landlord have any discretion to end it, or is it all up to the tenant?
The landlord can also terminate in the same grounds, just the same amount of notice. So with a year-to-year lease, the landlord would have to give a tenant 6 months' notice to vacate. Right? I mean, the idea is you're not supposed to be stuck there forever, right? This is the issue that comes in the Garner versus Garage case: is can you actually have a lease that lasts forever, right? There has to be some way that there's a leasehold to break it up. It's not like a fee interest. The fee simple, it's forever, right? But the leasehold is designed to be shorter duration of period. Good question. I guess all my examples are based on the tenant giving notice, but the landlord gives notice as well.
I just want to clarify that day six, like for February, you would need to cancel.
28. Right.
By January 3rd. Does that mean 28 days?
No, that's not correct. It's one calendar month.
Okay.
So if the lease begins January 1st, and you want to move out February 1st, right? Or you don't want to pay February rent, you have to give notice January 1st for January 31st. If you give notice on February 1st, then you can leave on February 28th. It's one calendar month. It's not 30 days.
Okay.
We'll get to the 30-day one a little bit later. That's the modern rule, which is a little bit more tricky. But the common law is one calendar month. And the leap year is 29 days. The common law rule is actually simpler. The modern one, you actually count days across months. All right, so that's 6A and that's 6B. Okay, let's go to number 7. All right, number 7. Okay. Number 7 is a modern approach. This is sort of what Ben was asking about a minute ago. The modern approach is both simpler and more tricky because you have to count. Okay. Under the modern approach, for a month-to-month lease, you must give 30 days notice to vacate. Again, under the modern approach, with a month-to-month lease, you must give 30 days notice. 30 days notice. So look at number 7A. It says from landlord to tenant for month to month, starting on January 1st, 2030. From landlord for month to month, starting on January 1st, 2030. All right. Okay, so I think put that down as next. I tell you on July 2nd, the landlord provides the tenant provides the landlord with notice to vacate. All right. Now, Tatiana, if this was under the common law rule, when would the lease be terminated? If we're under common law. Correct. At common law, if you put notice in July 2nd, it goes to August 31st. But Tatiana, we're in a modern jurisdiction here. Modern. So when would the lease? And what day is that, my friend? You know what? Print out calendars for exams. Just count days. I'm not being facetious. That might just be helpful. What's 30 days after July 2nd? Correct. Good job. Right? Yeah, good job. No, you got it exactly right in the first try. Very good. The end is August 2nd. Right? Under the modern rule, this lease will terminate August 2nd, 30 days after notice is given. So it's kind of weird. You have to pay rent for the day of August 1st, and that's it. So basically just one day of the August rent. The modern approach means you're slicing up the month into pieces. You only get the part of the month you're actually there for. So it's a lot actually more generous, right? In example 6B, you're stuck paying all the August rent at common law. And then example 7A, you only pay for the first day of the month, August 1st, and you vacate August 2nd. That's what it is.
So is the rate like prorated?
Yeah, so let's just make it easy. Let's just say it's $3,000 a month, right? That means $100 a day. So you just pay the $100 for the first day of the month. Yeah, I mean, basically the situation I had is they want to pay the whole September rent, right? They said you can't move out in the middle of the month. They pay the entire rent of September. Everybody with me? So, and the lease will terminate August 2nd, and you only pay the rent on the first month. Good? All right. All right, so we've covered so far terminating term of years, okay? Terminating periodic tenancies. And now we get to the last one, which is terminating the tenancy at will. A tenant at will continues so long as the landlord and tenant wish the lease to continue. Again, the tenancy at will continues so long as the landlord and tenant wish the lease to continue. If the landlord or tenant die, the leasehold terminates. If the landlord or tenant dies, the leasehold terminates. Remember, a periodic tenancy survives death. If the landlord dies, the heir becomes a new landlord. If the tenant dies, the tenant becomes a new. The heir becomes a new. Okay. With a tenancy at will, both the landlord and tenant have the power to terminate. They both have the power to terminate. And the rule in most states is 30 days notice, not a full calendar month. Right? Again, this is both in almost all states today, 30 days notice for tenancy at will. They're very rare. Right? Tenancy at will is very rare, but you must give at least 30 days notice. So let's look at number 8A. Okay, this is for Lillian. Okay. She's pointing left. not me. Yeah, thank you. All right, so number 8A. It's okay, you're next. From landlord to tenant at will, starting on January 1st, 2030. On July 1st, 2030, the tenant provides a landlord with notice of vacate. All right. So we have a tenancy at will, Lillian. In theory, when would it end if no notice is given? Okay. So they give notice on July 1st of 2030. When would this lease terminate? Correct. July 31st. Why is it July 31st? Correct. 30 days notice. Again, counting, right? From the first of the month, you add 30, goes to July 31st. Therefore, the tenant will not be responsible for the August rent. Okay? Alex, you're next. Look at 8B. The facts are very similar. Tenancy at will being January 1st, and you give notice on July 2nd. When does this will terminate? Or when does this lease terminate? What is the last day of the lease if it's 30 days? No. What is 30 days from July 2nd? August 2nd. The lease ends on August 2nd. The only day of rent you have to pay is August 1st. I think we're actually saying the same thing, but just hear me out here, right? When I say the lease date ends, it means you have to be out of there 1 a.m. on August 2nd. Now you pay the August 1st rent. You cannot be in the apartment. Vacating comes 30 days.
You give notice does not count.
I'm not dodging a question, but it's gonna make it hard if I try to answer it, right? Count. I'm just gonna count it. Right, I like this. Okay. Okay. All right, let's just find a calendar, right? It won't show the entire month, but it'll be close enough. Okay. You count July 2nd. You go 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 14, 15, 16, 9, 30, right? So the last day of the lease you're actually paying for will be August 1st. You don't count July. You don't count the first day. This is why I hate improv. Okay. You don't count the day you give the notice. And the reason why is presumably you give someone notice, they have to have notice of it, right? So if you give it to them at 11:59 p.m. on July 2nd, that's not notice. So we start 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, and then 30 is August 1st, and then that's your days notice, you're out. Okay? Right. So what happens when I try to do things on the fly? I know this seems simple, but I have to sort of walk it through. All right? So you have 30 days notice. From July 2nd, there's 30 days. Move out there. Yes, Brianna.
So, then in the example for 8A, the answer should be August 1st.
I'm getting myself in trouble here. Give me a minute. I want to make sure I say this correctly. You know what? I think actually I was right in 8A and I was wrong in 8B. I think I was actually right in 8A, wrong in 8B. I think Alex is right, actually. She's smiling. Yeah, no, I think it is. Yeah, no, I think she's right. You do count it. You know what? Yeah, no, it would be August 1st. Yeah. But I think actually you're right. So I apologize. It's okay. All right. So no, you do count the day of the notice. That's why I was getting tripped up. Okay. No, I was right the first time. Let's try this again. Yeah. What? 7A? Well, 7A is calendar month, so that's different. Which one was 7A? That was the you know what? Let me not do this now. Let me go take some time. I'm not under the gun, and I'll get back to you on Thursday. Okay? Can I do that? Okay. Because if I say this wrong now, it'll be really bad. So let me take some time to think about it. All right. I thought I had this clean, and it didn't work. All right. We'll come back to 7A and 8 next class. I don't want to do this right now because if I say something wrong, it'll be even worse. All right? Okay. Let's do the tenancy at sufferance last one, which was actually the sort of easiest one. This is number 9. Okay? All right. So far we've discussed 3 types of leaseholds. The term of years, the periodic tenancy, and the tenancy at will. Okay? So far, we've presumed that the tenant will leave the premise when the lease terminates. But what happens if the tenant stays on the property after the lease concludes? Right? This is the question of holdover. What happened if the tenant holds over? At common law, there were 2 remedies for holdover. The most obvious one is eviction, right? You can call the sheriff to evict the tenant. But the landlord could also create what's called a tenancy at sufferance. A tenancy at sufferance. A tenancy either through writing or through an implied agreement that is oral. And usually a tenancy at sufferance is subject to the same terms and conditions that were in the original lease. For example, the rent will remain the same. The tenancy at sufferance is a 4th type of a leasehold, kind of, but not really. And the reason why I say it's not really a 4th kind is a tenancy at sufferance closely resembles a periodic tenancy or a tenancy at will. It kind of resembles the other 2. I think 9A will illustrate this, right? In 9A, it says from landlord to tenant for 1 year beginning January 1st. Rent is paid on the 1st of each month. Okay? So this begins as a term of year for 1 year. Paid on the 1st of each month. The tenant holds over and stays past January 1st of 2031. this gives rise to effectively a periodic tenancy, right? But what's the period? So very often you have a 1-year lease and you stay over and you go to what's called month to month, right? That's how a lot of you maybe think of it. What actually happens under this rule, it becomes a year to year, right? So some courts say this becomes a year to year. The period is 1 year. 1 year is a December 31st of 2031. Everyone see that? By staying over 1 day on the term of years, you're effectively adding another year to the term. Okay. Here comes the rub. When you have a periodic tenancy, the usual rules kick in. You provide 6 months notice to terminate it. So to actually terminate this extended lease, you'd have to provide notice by July 1st of 2031. Right, so after a holdover, you basically create a periodic tenancy. Right, the tenancy at sufferance means you sort of suffer with it, right? The tenancy at sufferance acts as if it's a tenancy that's periodic. All right, and I'll get back to you soon with the other ones. It's very hard when I sort of spot an error in my own notes. I have to go fix it later, so I don't want to do this now and bother you more with it. So I feel awful about it, but I'll fix it up later. But, no, it's yeah, well, it is hard, but it's anyway. I'll check on it later. All right, question so far.
Is there a modern law rule for a year?
Right. Some courts treat it differently. Right. Some courts will say even so with a year-to-year lease, very often the rent is paid monthly. Right. So let's say you have a period of 1 year, a term of 1 year, but you still pay 12 installments of rent. What some courts will actually say is if you're paying the rent in 12 installments, we'll treat it as month to month. That's more of a modern approach. But the common law is whatever the period is, that's the period you use. All right. We have 15 minutes left. I want to do the Garner case, which is actually being removed from this book. This is the last time we're teaching. I like this case as well. Amar, I think you're next. Want to read the facts, please, in Garner?
Mr. Donovan, he is the person who owns the house, and he made a lease with Mr. Garish. And Mr. Garish, he leased the house to Mr. Garish, and they filled in blank spaces on like normal paperwork, and they wrote the party names and everything, and they read it out for $100 a month.
Mm-hmm.
And the landlord said that he reserved the right to come in at any point, right of re-entry if the rent wasn't paid at the time of cash.
Okay.
Give him a 3-day grace.
All right. So, Amar, you're pretend you're not a lawyer anymore. You're not a law student, right? And you're just seeing these two guys, and they write this lease. So they have this form book, right? And the lease says, for and during the term of blank, from blank, day of blank, which will end blank. If you just look at this form book, Amar, what kind of lease do you think the form was trying to create?
I would say a year-to-year lease.
A year or a term of years?
Or a term of years.
Be very careful, right? People want to say a year to year when they mean a term of years. There's term of years, and there's also periodic tenancy that lasts year to year. So which one is this, Amar?
Term of years.
You'll have a specific start date and a specific, correct. Have a specific start date and a specific termination date. But then, Sean, they filled in these buckets, right? So for blank number 1, they said, for and during the term of quiet enjoyment. What does that mean, quiet enjoyment? Yeah, but what does that mean, like quiet, not a lot of noise? What does that mean, quiet enjoyment? Up to who? Garish, yeah. The phrase quiet enjoyment doesn't refer to like loud noises, right? Quiet enjoyment refers to no one bothering your legal title, right? Quiet enjoyment refers to no one bothering your legal title. You've seen the phrase quiet title? You've seen that in different cases so far? To quiet title means to assert that no one else has any conflicting claims, that someone actually owns property that they say they own. So they say the term of quiet enjoyment, right? The term of quiet enjoyment from the first day of May 1977, where term will end. Lou Gehrig has the privilege of termination. And by the way, the sick just means it's an error. It should be a privilege of terminating, not a huge deal, but just so you know, that's probably the wrong word. Privilege of termination agreement at a date of his own choice. So I have to just ask in plain English, what did they intend to create here? What was like sort of the relationship they wanted to create? A tenancy at will, right? Both Sean, with a tenancy at will, can both parties terminate? But in this conveyance, can the landlord terminate the?
No, it says upon Garish's.
Correct. All right, everyone with me? All right. They tried to do something funky, right? They tried to get creative. A tenancy at will means that that both the landlord and the tenant have the power to terminate. But they created an interest that only the tenant can terminate. So the court has a question to decide. Is this an enforceable lease? What is it, right? Is it a tenancy at will? Is it a periodic tenancy? Is it a term of years? So Holden, how does the court handle this sort of novel conveyance that these two people drafted?
Well, the trial court ruled for Garner originally.
Why?
Because they found that when he died, the tenancy, when Donovan died, the tenancy went from.
So do you think it was a tenancy at will, trial court?
No, they turned it into a month-to-month period. But,
Well, what did the trial court hold?
they ruled for Garner and found that when Donovan died, the tenancy as well was converted into a month.
Okay, converted. Okay, that's correct. Right. So the trial court said this was a tenancy at will, right? And with a tenancy at will, when the landlord dies, the tenancy will concludes, and it gets converted to a periodic tenancy. At that point, the landlord or the new landlord can file notice. Okay. James, what happened?
Me?
Yeah, you're next. Oh, I'm sorry, Paige. I'm sorry. You're sorry. Paige. Yeah, you. Paige, what did the appellate court do? Okay. And then what did the New York Court of Appeals do? The highest court in the state.
They reversed it.
Okay. Why the highest court, the New York Court of Appeals, reverse?
Because they said that it expressly prohibited it does not reserve that right to the landlord.
What actual interest did Paige? What actual interest did the landlord give the tenure? What's it? Phrase you've probably not seen before.
Oh, like a life tenancy terminable at will.
Say it again.
Life tenancy terminable at will.
Yeah, a life estate determinable, right? What the heck is that? Basically, what the court said is that the landlord gave the tenant a life estate that can last his entire life unless the tenant cuts it short. So remember we have a fee simple determinable, right? Which is a fee simple that can be cut short early. The court says this is a life estate determinable. life tenancy determinable. Sort of a weird thing that you can keep it for life unless the tenant cuts it short. Okay, Jaime, what do we make of the fact that the landlord can't cut it short? Are the courts going to imply that term to allow the landlord to cut it short?
No,
Why not?
because it's unfair.
We don't there.
Well, the tenancy, I will, both parties are supposed to have those, and the ability to terminate the lease here as not the case.
So why shouldn't the courts imply that term, basically read that term to the lease?
Just because against what is tenant.
Correct.
I will.
Correct. Well, it goes against the intent. Is that what you said?
The tenancy, I want the tenancy, I will is.
Well, the tenancy and will, they both have the right.
Right.
So why wouldn't they imply this right here?
Because it's not, it just doesn't apply. I mean,
Why?
That's,
What do the parties intend here, Jaime?
the party intended for the lease, for the leasee to have to be the only one in terminate the.
Correct. Very good. Thank you so much. So here the court says we're going to follow the intent of the parties. Here it's very clear the parties only want to give this right. The landlord read that term into the lease. At common law, right? At common law is at common law, if one party had the right to terminate, the other had this right as well. The court would imply it. But here the court declines to imply that right because they want to follow the intent of the parties. So they say this is basically a life estate or a life tenancy determinable, which is sort of this weird thing, but they basically made up a new interest to reflect what it is that they wrote in their conveyance. So in the end, Garish could stay in the property so long as he continued to pay $100 a month in rent. All right. Questions on Garner? This is what happens when people sort of take the law into their own hands and write things into form books, and then they don't really know what they're doing. They create huge problems, but it happens. Yes.
So, I was just wondering, earlier in the class, we talked about, landholders having, future purchase inversion.
Yeah.
So, in the case, it talks about how, Garish only has the power to terminate as long as he's paying rent.
Correct.
So would that mean that the landholder have a future interest in like subject to the condition subsequent? Because, I mean,
Yeah, no, I know what you're doing. I know what you're trying to do. With a term of years lease, it's easy to say there's reversion. So know at a certain date and time, it goes back. It's a natural termination. I don't know that there's a natural termination here, right? Because it's at his election, right? It's when he chooses to stop the rent. So I'm not sure if you would say that the landlord is reversion here. I don't think that works. I think it would have to be. Yeah, right. I mean, yeah. Right, so I mean, yeah, no, I know what you're doing. It's actually very good, right? So when we talk about a fee simple determinant, right? The precedent is a possibly reverter, right? I would not say there's a possibly revert here. It's not really a term in leaseholds, but I know exactly what you're doing, right? There's because it's at the election of the guy. Now, if he dies, that would be a natural termination, but it could happen earlier. So I don't think it's reversion. Good question though. All right. Let me summarize a bit, and I will get back to you very quickly on that 7A and 8B. I'm beating myself over it because it's not happy about it, but it's 3 leaseholds, right? The term of years, the periodic tenancy, and the tenancy at will. Duration, right? You know the duration. The term of years is a fixed duration. With periodic tenancy, the period of time might be a month, might be a year, and they repeat automatically until adequate notice is given to terminate. Now, with tenancy at will, at least a common law, both the landlord and the tenant have the power to terminate. But under the modern approach we see in New York, we can have only one of the parties, the tenant in this case, able to terminate the tenancy at will, which is effectively a life estate determinable. They sort of made a thing up. All right, questions? Yes?
So would there only be a reversion for 10 years and then?
The term of years, term of years. Yeah.
There would only be a reversion for 10 years and then in a tenancy at will if the tenant dies?
Well, we don't know if he's going to die first or he leaves on his own. So I mean, this is Ben's question a minute ago. I would say that with a term of years, there's clearly a reversion. With the other ones, I'm not so sure. I wouldn't call it that. But definitely with the term of years, it's a natural termination. That one's easy. All right, other questions? All right, I will not keep you any longer. I'll see you in 2 days. We can count those days to see if I can count correctly. All right, I'll see you guys soon. Thank you.